Now that we have seen the different types of intellectual property rights, let us look at how enforcement of intellectual property rights can happen. One thing to bear in mind is that these rights, intellectual property rights pertaining to inventions, pertaining to creative works, pertaining to confidential information, goodwill, they are all different rights which can sometimes be used in conjunction with each other. There is a small degree of overlap between these rights, and we will have a look at the area in which they overlap, but predominantly they have evolved for serving different purposes. So the patents evolved to protect technological inventions, whereas copyright evolved to protect creative works. Trademarks evolved to protect origin of goods and the association of goods, and designs evolved to protect aesthetic designs or aesthetic works which were pleasing to the eye. Now, when an intellectual property is enforced, many a times in practice we find that enforcement does not happen in isolation. In fact, enforcement happens when the right owner applies, in most cases, more than one right to get an effective protection. So, when a patentee files a case for a patent infringement, most likely, if the case allows for it, there will also be a trademark infringement because the product may be covered by a patent and a trademark. When a patentee files a case for a patent infringement, say a device or a machine which can operate, it could be clubbed with a copyright infringement saying that the user manual with the machine is also infringed by the person who is copying the product. So you will find that for the same product, there could be overlapping rights, and the most effective way to protect a product is to have all these rights cover different aspects of the product. To understand how different types of intellectual property rights can overlap on a product, let's look at the example of the purple pill. The purple pill is a drug which is an acid reflux medication. It's sold in the United States and it is marketed as a purple pill. In fact, if you look at their website, it's called purplepill.com and it's a drug that is sold by AstraZeneca, and you will find various details about the drug. The purple pill exhibits almost every type of intellectual property that we have to study here. For instance, Nexium is protected by a trademark. It's a word that can be protected, so it's protected by a trademark. The chemical ingredient isomeprazole magnesium is protected by a patent. This was a subject matter of patent in the United States, and you will find there is a small R next to the word Nexium. Then the shape of the pill, though it's a generic shape, in some cases the shape of the pill can itself be unique. So the shape can be protected by design. In this case it's generic, but in cases where the shape is unique, it could be protected by design. Now there could be information with regard to how users should use it. What we call the user information can be protected by copyrights. And any trade secret which the company had while evolving this drug, which were not disclosed in the patent specification, could be protected by confidential information. And the entire getup of the product, the color coding, the shape, and the way in which it is presented, the packing, can be protected by the law of passing off, which is a right that is similar to trademark, but you can protect unregistered elements of your product through this right. So we see this in many cases where a product is released in the market. organization or a company would like to protect it with sometimes overlapping intellectual property rights. So you can see how a trademark, a design, in some cases there are pills that are specially shaped, heart-shaped pills and diamond-shaped pills. In that case, by a design, the chemical ingredient can be protected by a patent, the user information can be protected by a copyright, any trade secret can be protected by confidential information, and the entire getup of the product, the look and feel of the product, can be protected by the relief of passing off. Now let's look at the life of intellectual property. Because we have studied various different types of intellectual property, we need to see how these intellectual property rights have a life which is comparable to its term during which it can be enforced. Now, the life of any intellectual property right refers to the term during which it can be enforced. Now, the life of, say, a design is 15 years. It can be 10 plus 5 years. So it's a low life IP. So we will just put it here. Whereas the life of a trademark is very high. It can be renewed every 10 years and it can be renewed without any limit. So this is something what we call an unlimited life intellectual property. Now, between this extreme of a trademark which can be protected forever and a design which is a very short right, you also have patents. Now, if design is 15, then patents is 20 years. Then you have copyright as well. Copyright is life plus 60. And you have, along the higher side, you also have trade secrets or confidential information. So the life of an intellectual property right is dependent not only on the period that is granted statutorily. In the case of design, it's 15, patents 20, copyright 60, and trademark renewable every 10 years. It is also subject to modes of challenges. Modes of challenges in the sense that it can be challenged by the competitors in case they find that the patent or the intellectual property right is wrongly granted. So there is a high incidence of challenge for patents. It is pretty high because patents can be challenged by opposition, and this can be both pre-grant, and we had seen all these things. It can be both pre-grant and post-grant. And patents can be challenged also by revocation. And the revocation can be before the Appellate Board, Intellectual Property Appellate Board, or it could also be before the High Court where an infringement suit is pending. So you will find that there are multiple ways in which a patent can be challenged. A design can also be opposed, and there is procedure for opposing trademarks as well. So if you look at the modes of challenges, you will find that the life of an intellectual property right is also dependent on the modes of challenges. So if there are multiple modes by which an intellectual property right can be challenged, then the chances of that intellectual property right surviving or lasting throughout its entire term could be less. So from this we understand that there is something called a limited life IP. Now if I need to draw a line between these two sets of rights, we can call this limited life because their life is limited, and these two rights are called unlimited life IP. Now this will be important when we look at IP in business, that the limited life IP is something that is going to come to an end, and business manager constantly try to migrate limited life IP into unlimited life IP so that they can have a longer business advantage. Even within the IP, say for patents, there is a tendency to file more patents as the patents expire over the same invention so that they can manage the life of protection, which is also called portfolio management. Patent portfolio management is a device by which multiple patents are filed over a period of time on improvements and modifications in such a way that the life of the patent is extended beyond the life of the first filed patent. Now, let's also look at intellectual property in context, because some of these rights require registration and the others don't. Now, let's look at the ones that don't require registration. You have confidential information, and at the end where registration is a must, you have patents. And you have certain kinds of rights where registration can be optional. Even designs, it's a must. If you need to have a registered design, it has to be registered. Now, in between, you have, say, copyright, because copyright can be enforced even without registration, but there is a mechanism for registering copyrights as well. And you also have trademarks, because trademarks, unregistered trademarks, can also be enforced. So when you look at the line of enforcement, there are rights that don't require registration. Confidential information does not require registration, and there are rights that require registration. You can add geographical indications to this list, which mandates registration. Now, this also tells us that some of these rights are statute based and some are common law based. Now, confidential information is a common law based right. Copyright is a statute based right. We have a statute for it. Trademarks is again a statute based right. GI, design and patents, they are again statute based rights. By statute, we refer to there is an enactment passed by the parliament which has the formalities of how the right can be granted and how it can be protected. Now, what does IP protect? Because we have seen the different types of right that have come. There are some types of intellectual property right that protects the creative output. Let's put patents here. Patents protect the creative output in technological inventions, and also copyright. And when we refer to copyright, we also refer to all the related rights like the performers' rights, broadcasting rights, etc. We can also add design here, because some designs are, though they are aesthetically pleasing, they could be designs that are already there or that are slightly changed. The creative element in design could be considered to be of a lesser amount. And we can also add confidential info here, because not all matters that are protected by the confidential information regime needs to be creative. And this end, things pertaining to goodwill and reputation, you can add things pertaining to goodwill, reputation and origin. We can add passing off, which is a relief to protect unregistered trademarks, and even geographical indications. So the creative aspects of intellectual property right are protected by patents and copyright, and the goodwill and reputation rights that protect goodwill and reputation, like trademarks and passing off and geographical origin, can be regarded as rights that protect, whereas trademark, passing off and GI can be regarded as rights that protect goodwill, reputation and origin. Now, when to protect IP is another factor that any person who's interested in enforcing needs to consider. Some rights can be protected after they are granted, but a right during the course of its grant could also be challenged. So let us assume that there is a trademark which is granted at this point, or there is a patent that is granted. Now, for the trademark and the patent, there could be challenges that can happen after the grant. Now, we saw in the case of patents, there could be opposition, there could be revocation as well. For trademarks, there could be cancellation of trademarks by way of opposition. Now, some of these proceedings can happen in the granting office, that is the IPO in most cases, and some of them can happen at the appellate body, IPAB. And the appellate body proceedings are most likely post grant. So this happens after the grant. We'll look at this in greater detail, but this is just to let you know that enforcement is not something that is completely tied to the grant of a intellectual property right. Enforcement can also be considered even while the intellectual property right is being registered at the granting office. Now let's look at enforcement in further detail. Now what do we mean by IP enforcement? IP enforcement refers to the act of protecting your intellectual property assets, and it means that you are trying to stop free riders from causing harm to your intellectual property. You are trying to avoid losing the company's proprietary knowledge, and it could also mean that you are trying to solve disputes with regard to ownership. Now, the need to protect IP arises when somebody infringes your intellectual property. Now, infringement is a special word that we use for violations with regard to intellectual property. We also try to enforce the IP when somebody seeks to obtain a right that is actually yours. So your right is being violated. And also we seek to enforce IP when somebody obtains confidential information that belongs to you, something that is proprietary and something that is private information that belongs to you. Now you will find that intellectual property is at one level it is tied to some amount of secrecy. And that is true for all private property. Because a private person owns the property, he has private control over it. And the word private itself tells that there is an amount of exclusive control that person can have. For instance, what you do within the premises of your house is completely private. The law allows you that privacy so that there cannot be any third parties or external forces that come into you and disturb your privacy. Intellectual property, because it's private property, there is an element of secrecy that is in it. In almost every intellectual property, trade secrets can be kept as a secret as long as you have an agreement with a person. Patents before filing are kept as secret. Trademarks, especially in the nascent stage where they are developed, a mark is being developed or a logo is being developed, there is a tendency to keep it as secret so that people don't claim prior use over it. If somebody else takes the mark and uses it, then that person could have a prior user. So protect argument against prior use, you trying to keep the mark while it's being developed, while it's being conceived, private. Copyright, unless it is published, the world does not know, and unless it is published, you cannot let the world know that the subject matter of the creative work is protected by a copyright. So during the preparatory phase, the work in which the copyright would eventually manifest would be kept as a secret by the author. So this secret element is something that defines, or you can also say it's a confidential element. It is something that defines intellectual property right. Now, how do you enforce intellectual property? There are multiple ways to do it. Almost for all intellectual property, it is true that we can say that there is no mechanism of an automatic enforcement, in the sense that the fact that you have the right, you cannot stop others from using it. You have to enforce the right, your exclusive right, through a mechanism known by law. If you own a pen, let us assume that it's an expensive pen, The easiest way you can keep it from others stealing it is to keep the pen safely, preferably in a secure place where others cannot access it. Unfortunately, intellectual property by its nature, and we saw the traits of intellectual property, it is something that is available for everyone when it is marketed, and it is something that can be easily duplicated. Because of the nature of intellectual property, you should be careful about how you enforce it, because there are multiple ways in which you can enforce it and you can make the person stop. But the most effective way is to approach a court of law by filing a case. So that is the reason why intellectual property litigation is popular, and it is the only way you can enforce it. There are other measures wherein you can enforce the right but may not be as effective as approaching the court. For instance, you could issue a cease and desist notice. Now, this could be written by the right owner or by the right owner's counsel, pointing out to your intellectual property right and telling the person to cease and desist from infringing, and also giving a threat that if the person continues, that there will be an action of infringement. A cease and desist notice is, at the end of the day, it's only a written communication. The person who receives it, the alleged infringer, has an option to abide by the notice and stop the action, or the person can, if there are reasons to do it, continue with the infringement. So the notice itself does not mean anything unless it is followed by a legal action. So in most notices, you will find that towards the end, the person who issues the notice will have an indication or a threat of a possible legal action with which the notice is normally concluded. So notice is one way to enforce your IP, but it's not a guaranteed way. And even if you file a cease and desist notice, there could be instances where the person continues with the infringing action. Now, there are certain actions that you can take before the intellectual property office. Now, all these, you come to the enforcement part only when your right is granted. So let us assume that you have a patent that has been granted. Your competitor also files a patent making small modifications around your invention, and the application is still pending before the patent office. You can use certain procedures in the patent office like pre-grant opposition and file an application before the patent office seeking revocation of that right which is still pending, because your objective is that if that right gets granted, then it will be hard for you to enforce your right which is already in existence. So there are actions before the Intellectual Property Office which can be taken. There are cancellation and opposition proceedings for trademarks as well, which can be taken by a person who already has an IP. So to ensure that there is no overlapping IP, or to ensure that the competitors don't get what is called defensive intellectual property right, the rights that are registered just to ensure that others don't take legal action against you, the pre-grant mechanism, especially for patents, can be used effectively to ensure that your right is enforced. If the competitor's right is granted, as let us assume that the competitor filed a patent on a similar modification to your invention, and that has now been granted, and some time has passed, say a couple of years have passed, you still have a remedy to challenge it before the Intellectual Property Appellate Board by filing a revocation petition. So law affords you an opportunity to file action before the Intellectual Property Appellate Board to correct a wrong which you feel could affect your chances of enforcing your IP. There are civil and criminal actions. Both trademark and copyright attract criminal sanctions, and there are also civil. By civil, we mean the actions that you can take before the court. Every infringement suit is an action before the court, and you can have a relief of injunction stopping the person from doing the act. For instance, when you issued the cease and desist notice, and following the cease and desist notice, where you just ask the infringer to stop his activities, if the infringer continued his activities, then the remedy for you is to approach the court, telling the court that I issued notice, the person didn't stop. Now, so that brings us to the set of actions before the court, which can be civil, and in some cases like trademark and copyright, it can also be criminal. And you also have border measures. Border measures are with regard to import of an intellectual property. Say you have a patent protection over a particular technology, and you find that that particular technology is not protected in China, and there are Chinese versions of your technology which have been manufactured and which try to enter the country. Now, at the point of entry, you can use certain border measures to stop infringing articles. It is more effective for trademarks and copyright, not so much for patents, because of certain disputes that came up as to whether the border authorities, which are largely the custom authorities, have the power to determine patent infringement. And the courts have said that no, they don't have the power. So, but with regard to trademark and copyright, which is where it's easy to detect a pirated material, border measures are effective. Now, cease and desist notice means that you issue a legal warning to stop a person from doing something. Now, there can be an advantage in this because you put a person on notice, and you could definitely save on legal costs rather than going to the court directly. But there could also be some disadvantages, especially when you're dealing with pirated goods. Say there are quite a lot of pirated, copyrighted works. Now, if you issue a cease and desist notice, the person who receives the notice can quickly wipe out all the infringing material, and when you go for a search, a court-assisted search, nothing incriminating could be found in the premises. So the infringement material can be, especially in the case of fly-by-night operators, they can just dismantle the entire setup, and it will be very hard for you to find infringing copies to prove infringement. So you can give notice. Normally when you give notice of the rights. If it's a patent, you refer to the patent in your notice and tell them that this is a patent that is being infringed. And in your notice, you can also give a threat or a possible commencement of litigation. Now, there are provisions in the patent law where the threat itself can lead to a declaratory action. If the threat is groundless, the law allows you, under 106 of the Patents Act, the law allows the person who receives the threat, the alleged infringer, to approach the court to say that this is a groundless threat, so stop the person from making the threat. So there has to be some careful study before a notice is issued. Now, with regard to the actions before the IPO, there are largely opposition proceedings, and for patents, as we have seen, they can be an opposition proceeding before the grant by any person. So if you find that your competitor is trying to patent something very similar to your invention which has been granted, or you are prior in time, then you can use this procedure to go to the patent office and stall his application from materializing into an intellectual property right. And opposition proceedings can also be conducted 1 year after the grant by a person who's interested. But that becomes a tougher task to prove, because then your competitor already has an IP that is granted in his name. So it becomes slightly difficult to object or to oppose something that has been granted, but the pre-grant procedure is quite easy and it is quite effective. Similarly, for trademarks, you have a provision for filing opposition from within 4 months of publication of the trademark application. Before the Intellectual Property Appellate Board, which was established under the Trademarks Act and which also has technical members. So for trademark, there is a person who has a background in trademark. For patents, there is a technical member who has a background in patent law. You could make an action for revocation of your competitor's right. So it's a part of enforcement that you ensure that your competitor does not get an IP so that your IP can be enforced. And the IPAB generally also looks at appeals from the IPO, and it also has power of rectification, rectifying the register of patents. And the IPAB has reserved the power to decide these matters. So there is a bar on the jurisdiction of the courts. The matters, subject matters which are covered by the Intellectual Property IPAB, covered by the Intellectual Property Appellate Board, cannot be taken to the civil courts.